in the recent case of TechFab versus Medina, the Delhi High Court recently passed an ad interim ex parte anti-arbitration injunction on a prima facie view that the appointment of the arbitrator affiliated to a foreign institute is not as per the agreed arbitration procedure. So what are your views on that? What is the facts of the case that led to this decision?
Thanks, Soumya. I think we should actually go into what the facts of this case were. So the parties had an arbitration, had an agreement between them in which they had an arbitration clause, which had multiple requirements. But one very interesting thing was they said that the seat of the arbitration will be India or any other country. But the parties were later agreed that the seat will be India. Now, when disputes arose between the parties, one of the parties initiated arbitration. And they went to an appointing authority, which in this case was PCA. And the authority appointed an arbitrator who was affiliated with an arbitral institution based in Kuala Lumpur. Now, the argument which was brought before the court in this case, and on basis which an anti-arbitration injunction was sought, was that they said that because this arbitrator who was appointed was affiliated to a Kuala Lumpur institution, this was going against the arbitral procedure, which said that India was the seat of the arbitration. On that basis, the Delhi High Court ended up giving the anti-arbitration injunction. So basically, the two assumptions that they sort of made is that first, that if you have an arbitrator who is affiliated with a Kuala Lumpur institution, that means he will necessarily be conducting proceedings in Malaysia. And second, they're saying that and the second logical extension that they're driving at is that if they do conduct these proceedings in Malaysia, then you're going against the procedure which says that the seat will be India. So there's some confusion between venue and seat, and the affiliation with the Kuala Lumpur institution has something to do with seat no longer being India. Is the fear they had. So on this basis, they granted the anti-arbitration injunction.
So thank you for that, Ritika. I've read through the arbitration clause. Do you think there are any problems with the arbitration clause?
Yes, and as you would have read it as well, there are multiple problems. But let's first put down what the clause says. For example, first, the clause leaves it open for the parties to decide the number of arbitrators and the appointing authority at a later time. It says the seat will be India or any other UNCITRAL countries that the parties mutually decide. It says that governing law will be where the arbitration will be conducted. So there are multiple, ambiguities which have been left in the clause. Now, the problem which this leads to is that because it requires parties to agree on these things subsequently, it's practically very difficult that the parties will end up agreeing to any of these things once a dispute has actually arisen. So I think that's the fundamental problem with this clause, that it's leaving open these things. Mm-hmm. Now, some things you can possibly still leave open. For example, if you are leaving open, like some parts of it is still fine, like you want to leave some part of procedures open is fine. But if you leave out something like the appointing authority, it best becomes the basic details, that it becomes very difficult to then subsequently agree upon these things. So I think that is the main problem which also happened here, that in fact the number of arbitrators is because something the parties couldn't agree upon. One party proposed a single arbitrator, the other party never responded. But the parties are proceeding on the basis that they have now agreed upon a sole arbitrator. So things like that are going to be difficult. And I think that is what is the main thing here, that parties should keep in mind, that there's certain basic details they should definitely agree upon in their arbitration agreement. Otherwise, things like this are likely to keep arising.
Okay. Thank you for that, Ritika. I think I'd want to ask Arjun some questions now. Hi, Arjun. Thanks for being part of this discussion. So you just heard Ritika on the arbitration clause and how it had so many problems in the context of his judgment. What are your views on this?
I think the arbitration clause by itself is an impractical clause. And I think if there is a dispute pertaining to the dispute resolution mechanism, that poses a great problem to both parties to an agreement. Because then you will have to most probably subject yourself to the jurisdiction of a court to figure out what your actual intention to resolve disputes were. And that is definitely not a good starting point to resolve your disputes. So I think that having absolute clarity about the method and manner of your dispute resolution mechanism is an imperative requirement when you are drafting your transaction documents. We have seen in other cases as well, where even a small level of ambiguity regarding the law governing the arbitration or the express or implied manner in which Part 1 of the Arbitration Act is being excluded to foreign-seated arbitrations. These kind of aspects are allowing parties to raise threshold arguments before an arbitrator or an appointing authority. So therefore, having all bases covered at the time of drafting of transaction documents in your dispute resolution mechanism is definitely going to save you time from moving on from jurisdictional objections to actually reaching the meat of the dispute and going into the merits. So therefore, the idea is always to have a robust and all-rounded dispute resolution clause.
And let's get back to the judgment. How do you think this judgment is in the context of the previous precedents that have been there?
Well, this judgment, we have to keep in mind that this judgment was passed without the presence of the respondents. So it's an ex parte order. Keeping that in mind, the fact that the court went ahead to actually stall the ongoing arbitration proceedings seems to be a situation which is not too conducive for the general arbitration landscape of the country. There are defined principles governing grant of anti-arbitration injunctions. You need to have a situation where there is evidence of forgery, or that both parties or one of the parties did not give consent to arbitration, or if the intention of the parties was to do some other form of dispute resolution. In these kind of situations, we have obviously instances in the past where courts have granted anti-arbitration injunctions. But we are also seeing some instances where courts or tribunals, for example, the NCLT Mumbai bench had granted an anti-arbitration injunction in the Anupam Mittal saga. So these kind of injunctions, which are not very happily worded, which are not going into the historic jurisprudence surrounding such grant of such injunctions, might actually stall or pose a significant roadblock in the continuation of either domestic or international arbitrations. And keeping in mind the general history of litigation in India and the fact that dilatory tactics as a litigation strategy is not uncommon, this just might be picked up as one of those ways where people try their luck at getting an injunction on an ongoing arbitration. So I think for tribunals and courts to be very circumspect and to stay their hand and not at the asking give an injunction on ongoing arbitrations should be the rule, and only as a method of exception should such an injunction be granted.
Thank you for that.
Thank you.